In this honorable court.
Please be seated. We have two cases on the docket scheduled for oral argument this morning. Our first case is Eric Obogade, I believe, versus State. Counsel, you may approach.
Thank
Counsel,
you.
we will allocate you 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, sir. Can I please reserve 3 minutes of time for rebuttal?
So noted. You may continue.
May it please the court, my name is Luke Newman, and I represent Eric Aboigier. I want to start out by...
Can you pronounce his name again?
Aboigier
Thank you.
is the version that we're using, at least in my office. I want to start out by talking about something about which the state and I agree. The state and I agree, through the briefs in this case, that the state government, when it's prosecuting a citizen, may not intentionally elicit the fact that the citizen has hired an attorney. That's what happened in this case, and that's why this case warrants a reversal. In cross-examining a defense witness, the prosecutor, Mr. Aboigier's prosecutor, held a deposition transcript in her hand. The deposition transcript is part of the record in this case at this point. It's 27 pages in length. 2 times in that deposition transcript, the witness who was being cross-examined pre-trial had said, I confronted Mr. Aboigier with these allegations, and he told me he needed to talk to his lawyer. She said that twice in the deposition transcript. The prosecutor...
Why aren't you arguing more broadly? I mean, the trial counsel objected to this questioning several times as being beyond the scope of direct.
Yes, sir.
And there are a number of responses given by the witness that were pretty damning for your client, I would think, beyond just the attorney reference. I mean, she's talking about these other allegations, and it's sort of the broader context. But you're not arguing whether any of that was the broader picture, whether that was error that was prejudicial.
I agree with that.
You're just focusing on the reference to the attorney?
I agree with that. They haven't directly briefed those issues, that the objections based on that this line of questioning that related to my client's statements was outside the scope of the rec. So I agree with that there, but I think that helps us paint a picture, because later on we have this counter argument from the state in this case, in which the state says defense counsel chose not to object, right? And then when we go back and we look at the transcript of the cross-examination, when the state went away from the timeline defense, which is the reason the defense attorney put this witness on the stand, was about this timeline defense, that there's this allegation that Mr. Aboigier abused me, and after I was assaulted by him, I ceased babysitting for him. I didn't want to have contact with him, and I didn't spend time alone with him. His child came to my house, and I babysat the child there. And then through the course of the defense cross-examination in the state case, the defense counsel gets out through the alleged victim's stepmother, her father, the CPT interviewer, that didn't happen, that this individual kept having contact with Mr. Aboigier, including going to the home where she's saying that she was abused, right up until the time she made these allegations. And so I think that frames why it was important for the defense counsel to then call this other witness, who I refer to in my briefs with their initials, L.A., and to call L.A., who's the alleged victim's aunt, and who's not just an aunt, but an aunt who had raised the alleged victim as if she were a mother figure. She referred to her as mom, in order to get out this information that this alleged victim, who's saying she was abused and then cut off contact with Mr. Aboigier, continued to have contact with him, continued to babysit for him, continued to go to the home, right up until the time these allegations came out. At that point, then we switch, obviously, and then we get into cross-examination. And the state on cross-examination, and the transcript's clear, the state has in its possession this transcript of the pretrial deposition. The state then tries to get into these statements that Mr. Aboigier had made to that witness.
But no, but the it felt like I know what the prosecutor was doing when doing the cross-examination of the defense's witness, which I suspect was called for a very limited purpose, and was very careful to ask some very limited questions. And then the prosecutor gets up on cross and opens it up and then starts talking about the Vaseline and sexual relationship and all this other stuff, including her coming to him and making all these other allegations. Another one is coming forward, and then that's what elicited the response.
Correct.
About, oh, no, I need to call my lawyer.
Correct.
In that context, wouldn't almost anyone respond that way when faced with those kinds of allegations? You should probably contact a lawyer at this point.
I agree with that.
But that's not a suggestion that he's guilty. It's just a suggestion that's a natural reaction in the context of these larger questions that you're not suggesting were harmful error in this case.
Well, I think that the harmful error was not, I think that the harmful error was sniffed out by the defense lawyer, who then made the scope objections. And I agree, I have not briefed out specifically the trial court abuses its discretion in overruling the scope objections. But that's what led up to this. And I think this bleeds into another issue, a counter-argument issue. If we hear later, again, we didn't hear this at trial, again, because as soon as this came out, timely motion for a mistrial and objection were immediately made and argued, and then renewed overnight because we had an overnight recess. And
what was the
defense
basis for counsel's motion for mistrial?
Sir,
what was the basis for counsel's motion for mistrial?
The counsel said you knew that response was coming, and he said this, if we look at the transcripts, multiple times. You knew that was the answer you were going to get to that question. And he said, you elicited a comment from this witness on my client's right to be represented by counsel. And he said it immediately when it came out. They argued about it at sidebar, and then we had this state argument that, well, it's different because it's not a law enforcement witness. And the judge actually said, the trial judge said, well, my ruling would be different. I'd give you a different ruling if that witness on the witness stand was a law enforcement officer. But because it's just a citizen and not a law enforcement officer, the trial judge said, I'm overruling. And then we got into an evening recess where the trial broke, and we were going to come back and do closing arguments and jury instructions and deliberations the next day. And during the evening recess, counsel filed a written motion for mistrial and said, I want to readdress this issue. I was told at sidebar that the basis for the ruling was that the witness was not a law enforcement officer, but instead a citizen. But here's this case, he cited the Lenz case, and he said, here's this case, that's a distinction without difference. So then when trial reconvened in the morning, the parties were together in court, and at that point, the argument shifted. And what I was getting at, though.
But did counsel specifically argue that this testimony violated his Fifth Amendment right against self-incrimination?
He said it's classic grounds for mistrial to speak on my client's right to counsel, was the language that came out of his mouth. And I've quoted the argument in his argument at sidebar when he originally made the argument, and they had the sidebar on, let's call it day one of the trial. And then that night, he filed a written motion for mistrial. And I just have to refer you to the record on that. I don't know exactly what that motion said, but he said it's classic grounds for mistrial for that witness to speak on my client's right to counsel. And what we get then.
But it is a fact that citizens have a right to counsel. So I don't understand what the prejudice is to have it mentioned that someone may want to consult a lawyer when they have a legal problem.
Well, I then want to get back into that starts where we get back into the.
Isn't it a relevance thing more than anything else, and not a due process?
So the right to counsel and the right to silence issues have been kind of melded, and I would submit it comes from this Wainwright v. Greenfield case, which is a 1986 case from the U.S. Supreme Court. So these two issues are melded kind of when they come up in something like this gets said at trial. And then, yes, what you get into is, I think what we get into is whether or not it's relevant. And so in the limited instances where it's relevant, that it's in the case, and one of the cases cited in the state's answer brief referenced like a self-defense case where silence then would be inconsistent with the claim that somebody, he threatened me and so I shot him in self-defense. And so in those limited circumstances, it can come in, but it's irrelevant because if you have a right to counsel, you have a right to, you don't have to, bear witness against yourself. And these are the rights in the Bill of Rights. It's an assurance that's been made to you as a citizen by the executive, then to have the executive stand up in your trial and say, aha, he hired a lawyer, right? It's irrelevant, it's prejudicial, and it's a comment on this fundamental right from the Bill of Rights. And so it is classic. I agree on some level and with how the trial lawyer in this case phrased it when he said, that's classic grounds to have a mistrial. intentionally elicited from this witness that, you know, he had hired a lawyer. And so then we get into this other issue, and I want to make it clear, we get into the issue on appeal because it was not raised during the trial. And sometimes when there's a sidebar conference, you'll have an attorney on either side tell the judge, listen,
For
Your
what
Honor,
it's worth, I also have, and we didn't give ourselves a ton of time in this argument, but and do have some questions about your second issue as
yeah,
well.
absolutely,
But, I mean,
absolutely.
But
Let me say this, and I'll move on to issue number 2. And it's the first issue. We never had the state, beside the sidebar conference with the argument, the other argument the following morning, the state never says, well, you know what, that really just slipped out. That was unexpected. It was unresponsive. That slipped out and it surprised me as well. We never hear that. All right, now the Attorney General's office is arguing that on appeal. But despite the defense lawyer in this case at trial multiple times saying they knew that was coming and that was elicited on purpose, the state never once says, oh, you know what, that witness is hard to handle, kind of slippery testimony, and that just got blurted out on us and it was an accident. We never heard that. And so when we consider that counter argument, I'm asking Your Honors to take a look at the actual question, the actual question where she straight up asked him, did he ever say he didn't do it? Okay, I want to ask Your Honors to consider what you referred to earlier, Judge Tannenbaum, the scope objections leading up to that piece of testimony. And then I'll also ask you to refer to the lack of an argument after it came out that this was inadvertent, that this has slipped out from a witness who's just kind of blurting stuff out there on the witness stand. We didn't see any of those things. And so if we hear an argument later that, hey, this was an inadvertent slip by a witness who was unsophisticated or difficult to elicit testimony from, I'd like you to consider those 3 factors. Let me talk
Counsel,
about...
regarding your second issue, which you haven't addressed
Yes, sir.
yet, did the appellant preserve the second issue for appellate review by arguing below that CH hearsay statements were inadmissible under section 90.803, paren 23, close paren, because she was not the victim named in the charging document?
Let me tell you the exact objections that the trial counsel made in this case. At first, he said it's not appropriate in this case, and then he said it was cumulative. And then during the trial, when the state sought to introduce those child hearsay statements, what defense counsel said is, I'm renewing the earlier objections as to child hearsay. So those were the exact objections. And that's the extent of the exact objections that got made in this trial. And so
Are you, is it your position that, are you not arguing that her testimony was inadmissible at all? Like that, I mean, the other crimes evidence or Williams evidence or whatever you want to
the
call it.
hearsay about
No. I mean, but she testified. So
Right.
you're not arguing that it was error in any way for her to testify
I agree
at
with
all
that.
about that. Okay, so now it's just about the stuff that came after.
That's correct.
And is it your position that, well, what's your response to the state's argument that Dupree and the other stuff, that has to do with when they're not a victim at all, and when you have a sex crime victim, that the hearsay comes in as long as they're testifying?
No, I disagree with that. I think
And why? What is based on the text of the rule?
Right, I think what the rule has been limited by Dupree and then this court's Sheets decision. So I'm relying on Dupree and then Sheets to say if you have a Williams rule witness, the Williams rule witness, and I'm not objecting to that and I'm not arguing that on appeal, but to go the extra step, the final step, the hearsay from the Williams rule witness should not be admitted based on Dupree and based on Sheets.
I mean, what do you think I mean, it's an unusual rule. So, I mean, generally, the genesis of Williams in the first place actually excluded. It's like, well, as long as it comes in for reasons other than propensity, then it's relevant and it's admissible. And then we have a rule that develops. And then we have an exception to the rule, or a new rule, that says, yeah, for certain crimes, it can be for propensity, it could be, you could have a mini trial on this other crime to prove the charged crime, and that's apparently okay. And you're not arguing that that's problematic.
No, I'm arguing that the next step, that the bridge too far in this case is then to bring in the hearsay from the Williams rule witness.
So then what is your, I mean, let's assume you're right. Let's assume maybe your interpretation of that is the correct one. what's the prejudice? I mean, she's testified. And
Correct.
so, you know, it's just, I mean, maybe it's cumulative, but I don't even see you arguing that the cumulative objection here on appeal. So if it's just the hearsay and it was a misapplication of the rule, we're not going to look at the cumulative nature of it, just whether it's hearsay or not, what's the prejudice?
Let me weave it back into the first issue that I talked about earlier this morning. If we look at and we get to a harmless error analysis, I'm going to call the case DeGaio. Okay, DeGaio instructs us that we look at the permissible evidence when we're evaluating, when we're weighing the harmless error. So I'm weaving this back into the first argument that I made to you earlier, that if we look at this evidence, it's impermissible. And if we're going to weigh the mistrial issue, we're constrained, the court's constrained to looking at what was permissible. So if we're going to do the later weighing analysis, then those two issues dovetail with one another. I'm significantly into my rebuttal time. And
Counsel, I will extend your rebuttal time by 3 minutes. However, in reference to your second issue, you argue in support of your argument the Dupree line of cases. Now, did any of the Dupree line of cases involve the hearsay statements of another child victim whose testimony was admitted as similar fact evidence, as opposed to a non-victim child who merely witnessed the crime?
I think that was the Sheets. Didn't Sheets, I mean, Sheets is from this court. And so I believe in Sheets, those were the facts, that one of the witnesses was a Williamsville witness, and that they brought in hearsay. And then Sheets argued that. And then, so I refer you, if we're looking for that exact same procedural setup, I refer you to Sheets. And Sheets, again, is from this court, 1996.
Thank you, Counsel.
All right, I would reserve the rest of my time for rebuttal. Thank you.
May it please the court. My name is Charlie Lee. I represent the state of Florida. I work for the Attorney General's office. The first point I'd like to make is that I don't agree with the appellant that the Fifth and Sixth Amendments are melded in this case. There's very distinct rights here, and the Fifth is not at issue. The Fifth Amendment right to remain silent is one that citizens hold against their government, not Ms. Alisaria, who's the person who testified that the appellant asked for his lawyer. So the Fifth is not at issue. The only case that I could find was Nelson, but Nelson clearly states that when a man goes into a bar, doesn't make any statement, the prosecutor brings out to the other patrons about the shooting he just committed. The prosecutor highlights that, and that wasn't an error or a comment on his right to remain silent in that case because citizens hold that against their government. Now, Martinez and Lenz stand for the proposition that the prosecutor should not make a feature out of a defendant's right to retain counsel. That's a sacred right, and in those cases, certainly Martinez, the prosecutor did it when it wasn't relevant and made it a feature of the trial by asking many questions to witnesses and then bringing it up in closing arguments. The prosecutor shouldn't have done that, and that's not what happened in this case, and I'll get to some of the factual issues of why that's not what happened in this
Before you
case.
get to the factual issues, Counsel, was L.A.'s challenge testimony a comment on appellant's pre-arrest silence?
Ms. Alisaria's comment?
L.A., yes.
Sure, L.A. Yes, Your Honor. No, Your Honor. No, not a comment on his silence. And the reason is because she's not the government, and I think what the prosecutor's trying to, now, this is going into the factual issue, but if we look at L.A.'s testimony, it's a narrative, and it's not prompted by the prosecutor. When she says that, the prosecutor simply says, you know, did you, and I'm referring here to page 210 of the transcript, the prosecutor asked, he didn't say anything over the phone, I'm paraphrasing, and L.A. says that he didn't. But then L.A. goes, the prosecutor says, okay, and then L.A. goes into a narrative that ends with, he said, no, my God, let me call my lawyer. That is not a comment on his right to remain silent. It's showing his reaction to her accusation. And his reaction was not what a normal person would do and say, no, I didn't do that. I don't know what you're talking about. It's, I'm not going to talk to you about it, which is exactly what happened in Nelson. Well, not exactly what happened in Nelson, but in Nelson, the point the prosecutor was making is, instead of going into a bar and saying, you know, this shooting happened, I'm not at fault, what normal people would do, he didn't do that. And his reason was he didn't think anybody would believe him. And that's what if the prosecutor intended to get this testimony out, I believe that's what the prosecutor was going for. Now, I also disagree with the appellant's contention that the prosecutor intentionally elicited this testimony about counsel. It is in the form of a narrative. A lot of prosecutors, a lot of lawyers, when a witness, especially a witness for the defense, is speaking freely, well, the tactic is to let them...
Specifically, counsel, what was the prosecution's purpose in eliciting this testimony?
I don't think the prosecutor did elicit the testimony. I think the prosecutor was ready because the prosecutor had heard the testimony, and the reason I say that is on 211 of the transcript, when the defense attorney, Mr. Akbar, makes his objection, moves for a mistrial, the prosecutor says, well, first of all, this is not a law enforcement witness. She was ready for it, but I don't know that she elicited it. But assuming she did, the purpose there was I believe the purpose was to show that the appellant didn't react the normal way a person would. He didn't deny the allegations. And now, if the witness had been prepared, which would have been the defense attorney's job, she would have been prepared not to say anything about a lawyer. But that apparently didn't happen. It looked like the defense attorney from the transcript, my contention is the defense attorney was much more ready for this comment than the prosecutor was. And almost as if the defense attorney let the witness walk right into the statement. In that way, it almost seems like an invited error, but I can't make that assumption, just like there's nothing in the record to support that assumption. There's nothing in the record to support that the prosecutor intentionally
Was the
elicited.
evidence used as substantive evidence of appellant's guilt?
It was not, Your Honor. It was never mentioned again. It was an isolated incident, and therefore harmless under one of the cases, Shingledegger, that the defense cites in their brief, in their initial brief, where a video was played with the appellant invoking his right to counsel, his right to remain silent, and there they held it was harmless because it was an isolated incident and not made a feature of the trial. Unlike Martinez, where the prosecutor got up during closing and went on about how Martinez had hired a civil attorney to sue the police department that arrested him and made that an issue, that was an error. Now, there's a key difference in Martinez and Lenz, especially Lenz. There, in Martinez, the defense objected to the cross-examination regarding when the prosecutor cross-examined the doctor to bring out that the defendant had hired a lawyer, the defense objected, and the court allowed it. They overruled the objection. Later on, the defense didn't object when it came out in closing, if I remember Martinez correctly. Lenz, the court simply allowed the trial court to, they allowed the prosecutor to play the jail phone call where the defendant is talking to his wife about hiring a lawyer that knows all the loopholes. That's a totally different, well, not totally, but it's a different standard. It's abuse of discretion whether the court allows evidence in or not, and it's abuse of discretion of whether a court allows or grants a mistrial or not. However, the distinction is a motion for mistrial has to vitiate the entire trial, and it's an extreme remedy, unlike an evidentiary call. And that's the lens we have to look through at this case. The question here is whether a mistrial was warranted over this one comment. And the answer is no. It was never made a feature of the trial. The jury would assume he had an attorney. As Judge Tannenbaum pointed out, for better or worse, the defense attorney allowed L.A. to testify about all these other things that had happened, and L.A. was allowed to testify that there was a prior allegation referring to C.H. So the jury would assume he had an attorney because he already had allegations against him. And later on, they would learn that that was true, that there's Williams Rule evidence and that he had been charged with another crime. So it wasn't a prejudicial error. It wasn't one that would affect the jury. And it was certainly not an error that, or a comment that would warrant a mistrial.
Can you spend a few minutes addressing the, this is on issue 2, which seems to be taking a back seat on this. Can you address the intersection of other crimes evidence or other bad acts evidence, and that rule and that admissibility and the hearsay exception for child victims?
Yes, Your Honor. As I was reading the last couple of days, Dupree and Sheets, the cases they predate Crawford, and they speak about leading up to Crawford, the hearsay exceptions that are not firmly rooted hearsay exceptions of common law or what have you. They're presumptively unreliable for confrontation clause purposes. That's right out of Dupree. And then Dupree cites Lee v. Illinois and Idaho v. Wright, which are both about hearsay exceptions and the reliability and the fairness of using hearsay. So it's odd that it's in that case, because I was asking myself, why is there a rule that says that a child victim would be more reliable than a child witness? And Dupree even points out that, I'm sorry, I don't believe it is in Dupree, but you know, an adult victim or adult witness to a crime you can't get hearsay evidence from an adult witness. That's just rank hearsay. And that would be more reliable than of a child witness.
But Dupree seems to suggest that the exception in sub 23 is a narrow one.
That's what I was.
And if it's narrow, should we be reading the rule narrowly so that victim means the victim that is charged in the information?
No, Your Honor, that's what I was.
And the reason I asked for the intersection of that with the other crimes rule is, I mean, traditionally, like in other crimes, you know, the other crimes evidence comes in for a narrow purpose and it's limited. You have a limiting instruction, which was given here in an odd way, and yet here it's then used to backdoor all this other hearsay stuff, basically on another crime that's not charged. Instead of showing propensity, showing for the limited nature that typically this stuff's admissible, and it seems like it overtook the entire trial. Is that allowed? And is there a constitutional component to this?
I don't think so. I mean, first of all, it wasn't objected to well, the argument in the appellate's initial brief is not that it is limited to whether the rule applies to a child victim or a child witness. And the point, I just want to wrap up what I was saying. I think I was saying it rather clumsily, but Dupree seems to say that child victims are more reliable for some reason than child witnesses. And I'll assume that that's the case. I think when we view it through the lens of a Williams Rule victim, if that's what Dupree is saying, Sheets does not shed much light on that.
But counsel relies on Sheets in support of his position. Can you distinguish Sheets from the facts of this case?
Certainly. Here we have, as Judge Tannenbaum pointed out, it's kind of a mini trial. Now, whether that was I think it was fair to the defendant. I certainly don't think it was a harmful thing. Now, bringing in the hearsay was sort of gilding the lily. They already had CH testifying.
But CH's testimony was actually quite limited compared to the onslaught of the video and the text and everything else that took place right as the state closed the trial. So,
I understand, Your Honor, and I don't know that tactically from the prosecution's point that was the best procedure. But the argument here is not that there was a fundamental error. That's not the appellant's argument. The appellant's argument is limited to That the rule is, in Rule 23, it has to be the child victim to get these hearsay statements in, and that victim is listed to the victim, that victim is limited to the victim listed in the information.
Did she involve the testimony of a child witness as opposed to a child victim, which
It
we
did.
have in this case?
It says the statements of a child witness who was not the victim under Section 980323. So these are cases where it's just a witness and not the victim. Going back to the point from Dupree, the point of Dupree seems to suggest that child victims are more reliable than child witnesses. That, if that's the case, that's fine for the state's position, because here we have a child victim. We have a victim of the Williams Rule crime that's being used. And
Wait,
it's
so
not just
you-
a
so
Williams
you-
Rule crime under 90, I know that they
You
brought.
disagree with the statement in the cases that child witnesses of crimes are not victims?
I don't disagree.
Are victims, actually, that's a statement. That they agreed with Earhart's statement, for better or worse, that witnesses can be victims too.
I agree with that, but victims in a
So you're
different.
making a distinction of type of victim.
I think Dupree makes a distinction implicitly. It doesn't really explain why a child victim would be less reliable. It's speaking in terms of reliability. I mean, they cite Idaho v. Wright and Lee v. Illinois, which are about the reliability of hearsay and when that becomes a constitutional issue. Dupree doesn't shed any light on why a child witness or a child victim would have different levels of reliability.
Especially
And
considering they're both victims, apparently, just
They're both
different type of victims.
certainly, and that's why the rule in Dupree it really doesn't make a whole lot of sense, but especially applied to a Williams Rule case, because there you have a victim in the exact same way. CH was a victim in the exact same way that AJ was, just in a different crime. And that crime, as the appellant has conceded, was admissible as Williams Rule evidence, is also admissible under 9404C, evidence of past sex crime by the defendant. So that case could come in, and her child hearsay, I mean, she was a victim in that case, and that's why I'd ask this court to view it all through the lens of Williams Rule and 4042C, and find that no, despite the fact that the hearsay, CH's hearsay, was probably not necessary in this case, it wasn't prejudicial, harmful, or reason to overturn the appellant's conviction. That's all I have. Thank you.
Thank you, counsel.
I would like to address something that I neglected to say when I was arguing.
Before you
Yes,
get to
sir.
that point, counsel, involving counsels or the state's distinguishing sheets from the facts of this case, he noted that in sheets involved hearsay statements of a child witness who was not the victim under Section 98.80323. Will you find any case law where the child victim's testimony was not admissible under the statute in question?
Can I ask you a clarifying question? When you say the child victim, are you talking about the victim listed in the information? Or are you talking about another victim from another case that was introduced during the trial under Williams Rule?
Not the child victim in the case, but another child victim who was the victim of the crime by that defendant.
Okay, so basically what happened here, where we have another victim that comes in and says, I'm not the victim in the charging document, but I'm here to testify under the Williams Rule. And you're asking, I believe
Did you
that.
find any case law finding that testimony inadmissible?
I believe that's I know that I disagree with the state on this, but I believe that was the scenario in Sheets. And if I'm wrong, maybe I might move the court to ask to submit something on that, but I believe that was the Sheets scenario. Let me talk about.
What about the rule, though? I mean, no one's really talked about the text of the rule here today. In 23A, it talks about, it's not limiting, it describes the type of statement, and it has to be by a child victim, describing any act of child abuse or neglect. I mean, you know the rest of it, but describing any act of child abuse or neglect, and so on and so forth. How do you limit that rule? I mean, just the rule itself. I mean, you may disagree with whether that's, you know, a right rule or a fair rule, but it is a rule, and if we're talking about whether it's admissible under this rule, how do you splice that out?
I would splice it out by saying that the Supreme Court of Florida said in Dupree, which is from 1995, that that type of testimony is limited to the person alleged to be the victim in the charging document that the jury's deliberating about.
All right, so is your point then on that, and this is good, thank you. Are you saying then, like reading Dupree, even though the witness who was testifying there was a witness to a crime, the only way you can square Dupree with the rule is if they're describing basically a sex act or something that otherwise fits within this rule, that if you were just reading it as, well, it's any victim who's describing any act like this, not the person charged, that it should have come out the other way. But the fact that even though they are, quote, a victim, because they're a witness, and even though they're describing something that is otherwise covered under 23A, the fact that they were excluded anyway, it has to be because they weren't the victim charged in the document.
That's how I read
the main of
Dupree.
your argument?
Yes, sir. That's how I read Dupree. I see that I've exhausted my time, and I will be happy to submit Mr. Boisier's case on the briefs that we filed. Thank you.
Thank you, counsel.